Good afternoon. Welcome, and thank you for joining us for today's webinar on what's new in special assets. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Ward & Smith. Before we begin, I do have a few housekeeping items. We are going to utilize PowerPoint slides during this webinar, and I think it would be helpful for you to be able to see both our videos and the slides at the same time. To do this, you may need to make one adjustment to your view settings. Find the View Options button at the top or bottom of your screen and click on it to see your options. Then choose Side-by-Side mode. The slide deck should appear on the left and our videos should appear on the right. You can then slide the separator to the left or right to adjust the size of each view. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. We have scheduled time after each speaker's presentation to answer any questions you may have live. If you have a question at any time during the webinar, please type it into the Q&A box, and we will do our best to address all questions as time allows throughout and at the conclusion of the webinar. Now, I'll turn the mic over to Norman Leonard to kick things off.
All right, thanks, Jen. Good afternoon, everyone, and thank you for attending today's webinar. As Jen said, my name is Norman Leonard. I'm an attorney in our firm's Creditors' Rights Practice section, and I practice in the Asheville office. Also presenting with me today are Paul Fanning, who practices in our Greenville office and is the leader of our Creditors' Rights Practice section. Thomas Wolf, who practices Creditors' Rights and Business Law in our Raleigh office. And Tyler Russell, who practices Creditors' Rights and Business Law also in our Raleigh office. And for those of you familiar with Tyler, he also has a special focus in hemp and CBD law. As the title of the webinar indicates, there are a couple of new issues in the world of special assets that we think everyone should be aware of. And there are also one or two other hot topics that are technically not new, but which we think are worthy of some discussion, considering the economy and the increase in foreclosures and collections that we're all likely to see in the near future. So without further ado, I'll turn the webinar over to Thomas Wolf to present on our first topic, which is the new North Carolina Commercial Receivership Act. Thomas?
Thank you, Norman, and thank you everyone for attending the webinar today. Again, my name is Thomas Wolf. I'm here in the Raleigh office, and I'm going to talk about a brand new law on the books, the North Carolina Commercial Receivership Act, which is a pretty big deal. It's kind of taken the place of many of our current receivership laws that are in place and gave them a complete overhaul and updated them essentially for the 21st century. We had some on the books already, but they're so old, haven't been updated in so long, and really the negative aspect about them is that there's a very limited availability to take advantage of those procedures. Generally, lenders are very limited in when they can appoint a receiver to when there are cases where the collateral at issue is in danger of being harmed or stolen, damaged, or there's some kind of malfeasance by the debtor where they're mismanaging it. And so the new receivership law that is coming into effect allows us to take advantage and appoint a receiver to step in and preserve the assets of a business and restructure things, or alternatively dissolve and sell collateral in a much more broad, sweeping availability. So not strictly limited to those cases where there is harm imminent. As I said, this was a brand new law. It was signed in back in July of this year. It takes effect in January of next year, and it creates, like I said, a whole new statutory remedy. This seems to be the trend, as many states across the country in the past several years have been doing the same thing, creating uniform laws across the board to allow for receiverships to be used in a number of situations. The idea is to create a flexible state court supervised process, very similar to bankruptcy. Really can be thought of as a state court alternative. Instead of a trustee in bankruptcy, you're left with an independent receiver that can step in and take control of things. Just like bankruptcy, it creates a forum for all the creditors to get together, file claims, and gives them a forum to object and preserve rights and assets during the process. It's very streamlined. There's no real timeline like a bankruptcy plan may stretch things out for 3 to 5 years. So it's a little bit more flexible and gives the parties the ability to work towards a business solution, or if not able to be done, liquidate collateral and provide pro rata treatment to creditors' claims, very similar to bankruptcy. There's a much lower threshold for appointing a receiver than we have seen in the past. It's kind of hard to predict how it's going to be used going forward, but as folks start to gain familiarity with the laws and when it's useful, it's likely become just another useful quiver in our arrow in our quiver, so to speak, that can be used honestly for a debtor or a creditor, depending on the situation. Most importantly, it doesn't really displace any of our current laws on the books, statutory or otherwise. So if there are remedies that are available to us now, they won't be affected by this. This is just simply another available option that we can discuss and determine how it works into our strategy at the outset. So some of the advantages here, sometimes if you have a foreclosure that you're considering, you may not want to take title to property. You always have those situations, and I'm thinking, first and foremost of gas stations and those where there's environmental issues. There's oil tanks buried in the property. The bank doesn't really want to take title to that and deal with that on the back end. It may be beneficial to bring in an independent receiver to handle the sale of that. Maybe you don't want to take control of the full hotel or condo association. Sometimes foreclosure is not the best option. Involuntary bankruptcy, I don't really want to leave the debtor in control of their own operation in some of these cases. When you know that there's been theft, fraud, or malfeasance or mismanagement, bankruptcy doesn't really help get them out of control. Whereas a receivership, you can put somebody independent in right away, take control of things, and start to work towards rebuilding and stabilizing things. First and foremost, involuntary bankruptcy, probably not an available option to most creditors. When we're talking about using a receivership, generally you're a secured creditor that's concerned about some actual asset that serves as collateral for a loan. So involuntary bankruptcy is generally not an option for secured creditors. So even then, you're kind of at the whim of the debtor to file their own bankruptcy proceeding. And so who is eligible to bring this action? As the name implies, it's the Commercial Receivership Act. So it's strictly limited to commercial debt, either a commercial business or an individual debtor. As so long as it's not strictly consumer debt, it's going to apply in most cases. There are those few exceptions. You see them listed here: trusts, estates of deceased individuals, those in the military service, and certain state agencies. So outside those limited cases, so long as it's commercial debt, it's going to be an available option. And you have generally two different types of receiverships that we're talking about. In the case we're talking about the receivership controlling all or substantially all the exempt property, we're talking about complete control over everything. That's a general receivership. But in the vast majority of cases that we're probably going to see, I would expect to see a limited receivership where the control over the property is limited to just a portion, generally to that particular creditor's collateral that's at issue. You're most likely to see this because in most cases, as a lender, you're not really concerned with the overall operation of the debtor, so long as your collateral is protected and there's a way to get it back or sold and apply the proceeds to a loan. So we're probably more likely to see limited receivership on the creditor side versus the general receivership if the debtor wants to try to work things out or try to put things back together. But regardless, it's going to be beneficial to have the ability to appoint as the facts point in each individual case. The appointment process, very straightforward, a real broad application meant to be streamlined and easy and cost effective for everybody. Like I said, it's available to both the creditor and the debtor. It can be brought in a civil action in state court. Like I said, this is a state court run proceeding. And because it's in state court, it could be brought in so many different ways. It can be brought on its own, filing its own action for appointment of a receiver. It can be brought ancillary to another pending proceeding, whether that is a judicial foreclosure action, seeking money judgment, or a simple non-judicial foreclosure under a power of sale clause. So you have the ability to just bring it on its own, piggyback it to something that's already pending. Obviously you still want to get together and discuss the strategy at the outset with your attorney to make sure you're proceeding in the right fashion. But it's great to know that, circumstances change or the situation deteriorates. You can always fall back and bring in a receiver at any time. You're not foreclosed just because you start filing a lawsuit at some time. So grounds for appointment. There's some limitations on when you can bring the action, and depending on what type of receivership you're talking about, there's going to be different limitations. If this is before a judgment, there's still going to be a general limitation of a risk of danger to the collateral, some kind of loss or impairment, which the collateral is trying to preserve its collateral, or the creditor is trying to preserve the collateral or its rights to that. You can get a limited receivership before a judgment in that case. And then the second way would be to have it baked right into a deed of trust or the security documents, which isn't really a big issue on the housekeeping side for the lender, because most deeds of trust and security documents already have a provision like this baked right in. It's already there. Probably wouldn't take much to go back and shore up the documents and make sure it's in there. But as long as you have that provision, it's much more broad ability to file that motion for appointment, so long as you can show that it's necessary to protect the property. So you still have a little bit of a burden to show that there's something going on that would warrant getting a receiver, but still, it's much broader than it was before, much lower bar to consider. So the other is after judgment. Much more broader. You can get a general limited receivership at that point, and you can use this for a variety of reasons, like carrying out the effect of a judgment, disposing of property under that judgment. You can bring them in to preserve the property if there's an appeal pending, or you can force a receiver to sell property to satisfy the judgment, go after third-party claims that might be out there that the debtor is maybe refusing to pursue. So it's a great post-judgment recovery tool. And one of the bigger, broader applications that was brought into this new statute is that it can be brought on if the debtor is insolvent, if there's imminent danger of insolvency, they're not paying their debts, the business is being terminated, suspended, dissolved. If there's some danger to the business and now you're concerned about where things are going, having that provision put into your deed of trust or into your security documents is going to go a long way in protecting the lender and preserving its right to bring a receivership if things start to deteriorate like that. So who serves as a receiver? Generally, you're going to see somebody who's sophisticated, who is going to maybe be an attorney who devotes a portion or all of their practice to acting as a receiver and handling these things. They're going to have to paid a reasonable compensation for their efforts in the case, but generally, as long as they're an independent party in interest, they can be appointed. But once they're in place, they have broad discretion. They can do just about anything in control of the business. They take over the operations. They can take possession of property, preserve it, sell it. They can obtain financing. They can get unsecured loans on behalf of the business without court approval. They have the ability to get secured debt as well, so long as they get prior court approval. They can assert claims. They can file lawsuits. They can make demand for payment. They can even liquidate or dissolve a business or file a bankruptcy proceeding on behalf of the business. So broad control to do whatever they want. And real quickly, some of the benefits to a receivership just to be aware of. The big idea here is it's a streamlined process. It's meant to be much quicker and efficient than bankruptcy, but just like bankruptcy, you get a single judge who oversees the case from start to finish. You don't have to worry about going to state court and bouncing from one judge to another, whoever's holding court that date. But one judge oversees the entire process, keeping the costs down. The sale of receivership property is another great benefit. Just like in bankruptcy, you have the ability to sell your collateral free and clear of liens, so long as it's enough to fully secure the debt and take care of the debtor's exemptions, and nobody objects otherwise. Within 14 days, you can have collateral sold, disposed of, and avoid a foreclosure or a costly bankruptcy proceeding. So that's going to be one of the major benefits, just the ability to sell that asset, just like the bankruptcy process, without having to get involved with the full entire proceeding. You also have the ability to consolidate payments. There is a statute that provides that once the receiver takes control, all rents and payments due to the business or the business debtor need to go straight to the receiver themselves. So now you're going to avoid those issues where you have a tenant in the property and makes a claim that they paid the lender or they paid the business, and the checks between the two of them, and trying to track down where payments go. Now they're required to make those payments straight to the receiver, so you don't have to worry about chasing down payments. It's baked right into the statute itself. In cases where the debt and the assets exceed $5 million, you get the benefit of being designated as a mandatory complex business case, and it will be immediately sent to the North Carolina Business Court and have the benefit of a sophisticated business court judge to kind of look over things. So you don't have to worry about judges trying to get caught up on everything to take over. And again, post-judgment remedy is a great tool that we don't see very often, but sometimes there's a case where, as a debtor who has a claim against maybe a family member that they don't want to pursue, you can use it to our advantage and bring in a receiver to pursue that claim against somebody and recover from them and use that to apply towards a judgment as well. So we're not just talking about selling assets, we're talking about bringing in payments that are owed to a debtor to satisfy our liens. Just a great tool to have at our disposal if the case needs it. And I know I'm kind of coming low on time here and I'm trying to get through a lot of this, so I'll just really quickly run over the last drawbacks here. Just like bankruptcy, there's an automatic stay in place to be aware of. Just like that, in bankruptcy, it takes place as soon as the receivership's appointed, preventing us from doing anything to collect or pursue collateral that's part of the business without modifying that stay or having it lifted. And of course, bad faith filings is always something just to be aware of. Not that it's something that we would do, but if it's found that the motion to appoint was filed in bad faith, that we didn't have the right facts in place, you can be subject to damages, reasonable attorney's fees, and punitive awards. But again, putting that provision in the deed of trust or the security documents, allowing us to appoint a receiver is going to go a long way in trying to prevent some claims like this. So just a little bit of prevention on the front end, kind of discussing it and having a strategy overall before you get involved is going to help kind of avoid some of these issues. But generally, those are the big drawbacks to be aware of. And I know that I'm probably out of time at this point. I don't know if I've left enough time for questions, but certainly if there's something that anybody wants to ask me about, has any questions about this, feel free to reach out to me kind of offline and discuss. Otherwise, I will pass things back off to Norman Leonard, our attorney in the Asheville office, who's going to discuss some of the considerations between foreclosures and auction companies.
Thomas, before we transition to Norman, we did have a question come in while you were speaking. Can you please address the changes, if any, to asset-based lenders such as invoice factors?
I guess I'm trying to understand the question better about what the invoice factor is that we're talking about. I guess I'm not entirely clear on the question.
Okay. For the attendee who asked that question, we will come back to this at the end of the presentation as time allows. Thank you very much, Thomas, and we'll transition to Norman now.
Hi, thanks, Jen, and thanks, Thomas. As Thomas said, we're going to talk a little bit about the issues surrounding foreclosure auction hybrids. And by that, I mean a situation where a bank hires an auction company to assist it with the foreclosure sale. And to be clear, we're not talking about an alternative to foreclosure or substituting the foreclosure process with something else. If you're foreclosing under a North Carolina deed of trust, an auctioneer can't replace the trustee. The auctioneer can collaborate with the trustee and act as the trustee's sales agent. They can have an auction with all the usual theatrics. They can bang the gavel and do the do I hear bit and do all of that. But at the end of the day, it's going to be the trustee that sells the property, not the auction company. And the trustee has to comply with the foreclosure statute and the terms of the deed of trust. So there are going to be the usual service and notice requirements that must be met. There's going to be a high bidder that has to pay, the high bidder is going to have to pay the 5% deposit. The trustee is going to report the sale to the court, and everyone's going to have to observe the 10-day upset bid process that is prescribed by statute. So what we're really talking about when we're talking about foreclosure auction hybrids is supplementing or augmenting a typical foreclosure with the advantages of hiring an auctioneer. So what are the advantages of using an auction company with your foreclosure? Well, the primary advantage is marketing power. In the typical foreclosure, you have very minimal advertising. It doesn't have to be that way, but typically a trustee will post the notice of sale at the courthouse for 21 days, and then they'll advertise the sale in the newspaper twice during a 14-day period leading up to the sale date. And that's really all that's typically required of a trustee. By contrast, an auction company advertising, the auction company's advertising might include newsletters or emails to an established network of investors, and they'll probably have a website that has regional or national reach. And that kind of marketing can be a huge benefit if the property being foreclosed is the type that might attract non-local investors. Additional benefits of an auction company include the auctioneer's ability to follow up with people who make inquiries about the sale, to answer their questions, and to encourage them to attend the foreclosure sale. A good auctioneer can also demystify the foreclosure process for potential bidders by explaining it to those who've never participated in a foreclosure sale before. And of course, if you buy into it, perhaps the theatrics of the auction itself might encourage some bidders to be more interested in the sale than they might otherwise be. So as an example of a situation where a foreclosure auction might be useful, you might imagine a high value property located in a fairly rural part of North Carolina, perhaps a resort or something like that. And in such a situation, advertising in the local newspaper is probably not going to be sufficient to attract a high number of individuals who are the type of investors who would have the means and ability to purchase such a property. So utilizing the marketing power of an auction company in that situation is probably the only way that the lender will really have a chance to reach those investors in any substantial number and reduce the likelihood that they're going to have to take that property into REO. Now, it's important to understand that there are some bells and whistles of modern auctions that are not going to be compatible with a foreclosure. First, most auction companies today have robust online bidding platforms. You can't use it. A foreclosure sale has to be done in person at a particular time and at a particular location. Some auction companies will want to pre-register or pre-qualify bidders based on certain criteria, like creditworthiness. And this is not compatible with a foreclosure sale either. You can't put conditions on someone's ability to bid. Some auctions require bidders to pay a buyer's premium on top of the bid price. Again, this is the sale price is the only sum that can be charged to the high bidder. And lastly, the bank can't set a reserve price. The only way to establish a minimum bid is for the bank to be prepared to credit bid for the property at a price that the bank is willing to pay, and thereby force other bidders to outbid the bank. And we'll talk a little bit more about credit bidding in a moment. The next consideration is location. Where can you hold your foreclosure auction? For this, it really depends on what the deed of trust says about the sale location. If the deed of trust is statute, then by statute, the sale must occur at the courthouse steps. If the deed of trust allows for a sale at the property being foreclosed, then technically the bank is allowed to hold the sale at the premises. Depending on the type of property involved and your local county courthouse, sale at the premises may have some advantages. It could be more convenient for bidders. It could provide easier parking, and there might also be fewer distractions that could complicate the auction. It could also be attractive to some bidders who might want to get a closer look at the property before bidding on it. But if the bank is interested in an on-premises foreclosure auction, then you'll need to remember first that the bank doesn't own the property. Until a foreclosure sale is final, the borrower still owns it. So the borrower will need to consent to an on-premises sale and provide access to attendees on the day of the auction. So it's a situation where you're completely adverse with the borrower and the borrower is not cooperating and doesn't perhaps care about how much the property is ultimately going to sell for, then an on-premises sale may not be an option for you. With an on-premises sale, there also might be concerns about liability. If, for example, someone were to attend the sale and get injured, perhaps falling down or something like that, you can certainly walk around and ask for liability waivers from attendees, but you really can't make signing a waiver a condition of attending the sale or as a condition to bid at the sale. Again, a foreclosure sale is a public auction. It needs to be open to anyone who's willing to bid. As I mentioned earlier, there's no reserve price in a foreclosure sale. So the ability to strategically credit bid is going to be necessary to protect the bank's interests and prevent the collateral from being sold for less than the bank is willing to release it. So the bank will need to plan on sending a representative or an attorney, someone to bid on the bank's behalf. And the bank and auctioneer will want to discuss the strategy for prior to the sale. Unlike a typical foreclosure where there's no advertising and no auction, and the trustee shows up to the courthouse steps, they announce the credit bid right away, and then there are no bids and everyone kind of wanders off to go finish their cigarette. In this case, you'll probably want to hold your credit bid in your back pocket. This will give the auctioneer some time to engage the crowd, get them vested in the property, and then see if the bidding comes up to close to the credit bid amount. Then hopefully, if it doesn't quite get to the price that you want to sell the property for, you can deploy the credit bid and push them over the line. Of course, if things go well and there's robust bidding, the hope is that the bank doesn't have to place a credit bid at all. But it needs to be prepared to do so if necessary. Arguably, the most important consideration in the foreclosure auction scenario is going to be the contract between the bank and the auction company. Some auction companies will have a form contract that meshes well with the foreclosure process, but others won't. For those, the bank will need to modify the contract to ensure compliance with the foreclosure statutes and to set the budget and scope of the advertising that is going to be expected of the auction company to make sure that the bank is getting good value for the compensation that it's paying. Critically, the bank will also want to make sure that the compensation structure makes sense and accounts for all the possible outcomes that might occur in a foreclosure scenario. Obviously, the contract will probably provide an attractive commission to an auctioneer that is successful in selling the collateral to a third-party bidder at a good price. But if things don't go well and the bank ends up being the high bidder, you may want to have a lower commission or a flat fee to compensate the auctioneer for their labor, but account for the fact that this was not the result that the bank was hoping for. Likewise, you may want a flat fee if there's a workout, a refinancing, a bankruptcy, or some other event that occurs and terminates the foreclosure before it becomes final. And the bank will also want to account for the possibility that the high bidder will back out of the transaction. This happens from time to time. If it does, you'll want the contract to clearly state how the auction company will be compensated for its efforts and whether they will participate in a resale. And if so, on what terms. Finally, another consideration may be any personal property that's located at the premises. Here we're typically talking about furniture and equipment that is used in connection with whatever business was being conducted there. If the bank has a security interest in these items, then it will often be governed by a separate security agreement. And it will also probably be governed by different statutes, namely the Uniform Commercial Code, rather than the foreclosure statute. So, depending on the circumstances, foreclosing that personal property may require separate notices, additional advertising, and a separate auction altogether. And the bank should really weigh the merits of whether it makes sense to sell it at an auction in conjunction with the foreclosure sale or in an entirely separate auction. For example, if we're talking about a hotel that has furniture in it, then it may be reasonable to foreclose the real estate and sell the furnishings at the same time. But if we're talking about a warehouse with expensive equipment inside, then the equipment may well do better in a separate online auction. So these are the basic issues to consider when thinking about hiring an auctioneer to assist you in a foreclosure situation. The situation, to contrast this with something that Thomas mentioned in his presentation, if this is an environmentally compromised property or a property that the bank definitely doesn't want to take into REO, then a foreclosure auction is probably not the best fit, because ultimately, again, you have to be prepared to credit bid at the sale and take the property if necessary. If it's an environmentally compromised property and you want to take title to this property under no circumstances, then a receivership might be a better option. So I'd be happy to take any questions if there are any.
Thank you so much, Norman. We did not have any questions come in during your discussion, and I think we can move to Paul's presentation.
All right, well, thanks, Jen. With that, I'll hand the reins over to Paul Fanning to discuss Subchapter 5 bankruptcies.
Great, thank you, Norman. Thank you, Thomas. Good afternoon, everyone. Thank you for joining us for this webinar. This portion of the program is about the Small Business Reorganization Act of 2019, not to be confused with COVID-19. It will highlight how this law will affect special assets. I've gained some knowledge on this by studying the law, speaking at seminars, and practicing in about 6 or 7 Subchapter 5 bankruptcy cases so far this year. Because we're constrained by time and the topics, this is going to be a high-level discussion, but it's meant to highlight what's important to the special assets side of the business. This is a big deal. This is going to change the way that we deal with most bankruptcy cases. This law came into effect on February 19th of this year. Because of the CARES Act, which took effect at the end of March of this year, it increased the debt limit cap from $2.7 million to $7.5 million, making this particular subchapter of Chapter 11 bankruptcy available to more businesses and individuals. I suspect once we see the effects and the positives that come out of this particular bankruptcy subchapter, that the cap may become a permanent cap of $7.5 million. The debtor in these cases gets to elect whether to be dictated by this subchapter and the rules that under which it comes, and they obviously have to qualify. The purpose of the law is to streamline the process by which small business debtors reorganize and rehabilitate their financial affairs. It is designed to allow the filing of bankruptcy in a timely, cost-effective manner, which is hopefully allows them to stay in business, which not only benefits the owners, but the employees, the suppliers, the customers, and others who rely on that business. Why is that important? Well, that's because the courts have taken the legislative purpose of this law into account when they apply the law to a particular case. It's estimated that since October of 2007, approximately 40% of the Chapter 11 debtors that have filed across the nation would qualify under this subchapter, and roughly a quarter of the individuals who file Chapter 11 would also qualify under this subchapter. So this is something that we anticipate will be a popular election for debtors filing bankruptcy. That doesn't even consider the COVID-19 pandemic and how that will increase bankruptcy filings across the board. Subchapter 5 resembles a Chapter 12 bankruptcy case in many respects. There's a trustee appointed, not super active, but allows the debtor to remain in control of the assets and the business. The trustee has oversight and monitoring duties and has the right to be heard in certain matters. In some cases, the trustee may make disbursements to creditors, and we'll talk about that a little bit more later. There is no co-debtor stay in a Chapter 11 case of any kind, including this one. So just to be clear, there's a Chapter 11 debtor, there's a Chapter 11 debtor in a small business case, and then there is a Chapter 11 subchapter 5 small business debtor, and that's the subject we're talking about today. The modifications of traditional Chapter 11s include the following. There's no committee of unsecured creditors. There is a required status conference early in the case, within the first 60 days. The debtor has to file a report before that status conference, which will be explained further below. The time for filing a plan is expedited from the normal 300-day limit to 90 days. There is no disclosure statement requirement in this new subchapter 5, although the plan must provide a brief history of the operations of the debtor. It must also provide a liquidation analysis and projections with respect to the ability of the debtor to make payments under a plan. So although there's no requirement for a disclosure statement, there are some requirements that would set creditors in a good position to decide whether to go forward with the plan or not. One of the real benefits to creditors is the increased transparency. I see my friend Joel Barrier on the call, and Matt Smith from the Finley Group, and we once had a case where hide the ball was the debtor's playbook. And we had to get testimony from our expert, Matt Smith, to tell the bankruptcy judge that any debtor in that position would have a balance sheet or a statement of operations or a cash flow statement. That is a requirement, and it is a requirement on the front end here. When the debtor files, they've got to file all those things. They've got to file a cash flow statement, in addition, federal income tax returns, or a statement under penalty of perjury that they don't exist or they haven't been filed. Throughout the case, the debtor has to file periodic reports. This is also good for creditors. Those reports include the debtor's profitability, reasonable approximations of the debtor's projected case receipts and cash disbursements, comparisons of the projections to the actual to gauge the performance of the debtor through the case. The debtor must state whether it is in compliance with the requirements of the bankruptcy code, and if not, whether and how it will get into compliance very quickly. So this is serious business for the debtor. The debtor's senior management has to play a pivotal role, of course. They have to attend the meetings and especially the first meeting of creditors. They have to file all the schedules and statement of financial affairs. They have to file all the financials. They have to maintain insurance particularly associated with collateral and assets of the estate. And the trustee in the case, which we're going to talk about now, has the right to inspect the debtor's books and records and premises. Another thing that's really good for creditors in these cases is a trustee is appointed in all cases. Again, that's good for creditors. There's an impartial third party typically with knowledge of the bankruptcy process appointed to supervise or oversee or assist to facilitate the development of a consensual plan of reorganization in the case. The trustee in the case, we are so far seeing that those trustees are handpicked debtors' counsels within the cases that I've been involved, but there's no reason why they couldn't be a business person, a CPA, a turnaround professional, or anybody knowledgeable and willing to serve in that role. Finally, the trustee must appear and be heard at certain hearings or events. If there's a hearing on the value of property subject to a lien, or if there's a hearing on confirmation of the plan, or modification of the plan after confirmation, or the sale of property to the estate, the trustee must play a role and provide input to the court on those issues. We're going to talk about confirmation of a plan, the difference between a consensual plan and a cram down plan, but one other role of the trustee is to make payments under a plan if it is a cram down plan, and we'll talk about that in a little bit. The status conference and the debtor report are a big deal because early in the case, the debtor is put before the court and asked some really hard questions. 2 weeks before that hearing, they must file a report to the court, and the report for the court must include the following: efforts the debtor has undertaken or will undertake to obtain a consensual plan of reorganization. Also, the goals of the reorganization plan, any complications the debtor anticipates, any need for litigation, discovery, valuation, or litigation of any kind. It also must contain a description of the nature of the business, where it's located, number of locations, the number of employees, and how it normally operates its business. It must also address the goals of a reorganization plan, any motions the debtor intends to file, any objections to claims, the estimated time by which the debtor expects to file its plan, and whether the debtor is current on its tax returns or any other matter that can affect the efficient administration of the case. Again, we're talking about transparency, and we're also talking about efficiency, speed. Often is the case where debtors are in bankruptcy too long, the professional fees add up, and the debtor is no longer insolvent or administratively solvent in order to arise from a bankruptcy case. So that gets us to the plan confirmation process. In this new law, there are major incentives for the debtor to attain a consensual plan. So gone, supposedly, are the days of the debtor ignoring the creditor and then surprising them with an onerous plan that draws numerous objections and a long period of time before a plan is in place and the debtor is held accountable. This new law is quicker than that. It also gives many incentives to a consensual process. A plan can be confirmed easily when there is consent of all the creditors, it's proposed in good faith, and it's feasible. If the court finds or that those factors exist, it has to approve the plan. That sounds easy. Cram down confirmation is the alternative, and that gets complicated. Absent universal consent, the court will confirm a plan if it does not discriminate unfairly against holders of claims. It is fair and equitable to each class of claims. And with respect to the unsecured claims, all projected disposable income of the debtor is paid over between 3 and 5 years typically. Doesn't require payment in full of those claims, and it allows debtors to retain property. In addition to those factors, the court must find that the plan is feasible and that the debtor can do it. In addition, and this is new, a cram down confirmation under subchapter 5 requires that there be appropriate remedies if payments are not made. This is where the consensual plan and the negotiation takes a hold, okay? What does disposable income mean? Well, it's basically the income received less the amount reasonably necessary to be expended for maintenance and support of an individual or to keep the business going in a business. The confirmation is binding on all debtors and creditors and any other party, regardless of whether they voted for or against the plan. That is typical and nothing new. The effect of confirmation also vests property in the debtor unless the plan provides otherwise. Next part is discharge, and another incentive for the debtor to get a consensual plan confirmed is that discharge is granted upon confirmation in that sense. This is a huge incentive for the debtor. They don't have to worry about making payments over the life of the plan. If they've got a consensual plan, then they get discharge of everything else on confirmation. In a cram down plan, the debtor does not get a discharge until after all the payments are made under the plan. So that can be an additional 3 to 5 years. Appropriate remedies is where the rubber meets the road for special assets. This is where you really need to get creative. So I'm going to give you some examples of some of these things, and these are where you need to pay attention. Obviously, payment terms, events of default, the remedies on default, lifting of the stay at certain points of time, in rem relief from the automatic stay, such that a future bankruptcy will not stay creditor process against collateral, turnover of collateral, default notice provisions. One I really like to put in is, because your loan documents are always so strong, except as modified, the loan terms apply. Or if the case gets dismissed before a final decree, then everything we agreed to in this bankruptcy case is null and void. That's an opportunity to be creative. A cram down plan, of course, needs to have appropriate remedies. In addition to those listed above, one thing the statute cites is liquidation of non-exempt property. So that's a big tool or weapon for creditors to use in the plan confirmation process. So with that, my presentation about the new subchapter 5, chapter 11 bankruptcy is done. If anyone has any questions, please let me know.
Thank you so much, Paul. We did not have any questions come in during your presentation. I will remind our attendees that if you do have questions for Thomas or Norman or Paul or Tyler, who is going to present next, we also will have a few minutes at the end of the program to address those. And Paul, I think we can turn things over to Tyler.
Great, thank you.
All right, thanks, Paul. Hey everyone, my name is Tyler Russell. I'm an attorney here in our Raleigh office at Warden Smith. Know many of you that are on the call and have had the pleasure and opportunity to present to several of you in the last few months on some of the issues that I'm going to discuss today. We are running short on time, and I do want to make sure that we carve out a sufficient amount of time to answer any questions that the attendees may have. So I'm going to keep my comments very high level as well. I'm going to talk about two things: cannabis and COVID, and some of the expectations and impacts that both can have on the banking industry, and especially the creditors' rights side of the banking industry. As Norman mentioned earlier, I am one of the leaders of our firm's hemp practice group. I also, for the last decade, have been a member of our firm's creditors' rights practice group. So I kind of live in both worlds and see the issues separately and as they cross over. We've had a number of banking clients recently have and encounter issues with the cannabis space, both hemp and marijuana related issues. So it's certainly a trend that's on the rise across America as more and more states legalize medicinal or recreational or adult use, if you want to call it that, marijuana programs, as traction picks up on the federal level to discuss and consider cannabis legalization. And especially since the 2018 Farm Bill passed on the federal level, which legalized hemp, which is a low THC form of cannabis on the federal level, and removed hemp and hemp derivatives and extracts from the controlled substances list. Marijuana is still federally illegal. Marijuana is still considered a Schedule I controlled substance on the federal level, but hemp is no longer an illegal controlled substance on the federal level. So what is that? The difference between hemp and marijuana is the chemical component of delta-9 tetrahydrocannabinol, or THC, which is the substance in the cannabis plant that causes your psychoactive or euphoric high type of effects associated with marijuana usage. The threshold is 0.3% delta-9 THC by dry weight. Anything that contains that or less is hemp. Anything that contains more is marijuana. There are a number of banking regulations to consider when these issues come up. So if you have a borrower that's involved in the space, or you send a appraiser, for instance, into a building to do an inspection and you find an illegal grow or some other cannabis related venture that you weren't expecting to be there, you do need to involve your compliance officers early and often in the process. There are Bank Secrecy Act obligations and reporting obligations, including the filing of suspicious activity reports that may be required. The bank has to follow all of those things pretty closely and check the boxes to make sure that it's mitigating its risk in that situation, and that it's keeping itself in the safe harbor provisions of the Bank Secrecy Act. Last thing you want is to be accused by a regulator of facilitating or participating in some way in an illegal or money laundering type of scheme. USDA is the primary regulator for hemp in the U.S. at this point, for hemp production in the U.S. States are opting in to state-by-state hemp production laws and laws and regulations governing the manufacture, production, and sale of hemp and hemp products within their borders. This is creating a patchwork of laws and regulations across the country, which means that there's more room for confusion, more risk exposure when dealing with issues centered on these industries. And it's just a heightened area of risk for banks to participate in. So you've just got to be very careful to know what laws apply. It may be more than the laws of the state where the customer or the business is physically located. You just need to dot the I's and cross the T's and talk to people who are experienced and knowledgeable about these things to make sure that you're mitigating your risk and in dealing with it and planning appropriately for whatever action needs to be taken in response to that issue or that discovery. The FDA is also involved in the hemp industry as a regulator for the manufacture, marketing, and sale of hemp and hemp products after the cultivation period ends. So once the plant is harvested and you start making it into other things or selling those other things, the FDA and to an extent the Federal Trade Commission, the FTC, are also involved in regulation of the industry. But as it relates to hemp, the DEA is out of the picture. But for marijuana, the DEA is still involved, and controlled substance regulations still apply to that as well. That is it for hemp and marijuana banking issues. Certainly am always happy to dive into that more. It's easy to go down the rabbit hole. And so we're always happy to speak with individuals or lenders or banks to help kind of educate on more specific issues or give you a wider breadth of the issues that you could encounter and the information you need to be able to issue spot and analyze those problems. Moving on, COVID-19 related trends and concerns that we've seen. PPP money has burned out. That program closed in August. There's still a significant amount of unallocated money from the CARES Act for that program. No one is quite sure yet what Congress is going to do with that, if they will reallocate that money towards some additional small business relief bill or program. And we're also largely unsure as to what the forgiveness program is going to look like for paycheck protection loans that exist currently. I understand that yesterday, Federal Treasury announced that it's going to begin reviewing and approving for forgiveness applications. And I understand that they expect to move those along at a pretty good click, but loans over $2 million are going to have additional scrutiny. Beyond that, there's not a lot of specific hard detail at this point in time. So we're in a wait and see as to how that's going to affect businesses. Certainly as that money goes away and is no longer available, there's a question as to how quickly businesses will be able to bounce back if their individual economic sectors and activities have improved during that period of time, or if they're now just going to find themselves in a situation where they still have limited operations, limited cash flow, flat expenses, and no more available cash to float operations. A lot of industries are hurting right now, and we're already seeing an increase of bankruptcy filings. For instance, in the retail, in the hospitality, agriculture, and energy industries. We expect that trend to continue and to bleed into other sectors of local and national economy as well. And the general consensus amongst practitioners is that we're going to see an increase of default activity towards the end of the year, with an increase in foreclosures and bankruptcy filings after that. There are moratoriums and prohibitions in effect for some residential evictions through the end of this year. Those do not apply to commercial evictions and foreclosures, but we're still seeing a number of commercial lenders err on the side of caution and fairness and enter into extensions and forbearance and modification of debts in light of the pandemic. I personally have seen somewhat of a slowdown, although that still tends to be the practice in most of the files that I'm personally handling in the creditors' rights realm. Although I can tell that the rope is running out, at least with my clients and my activity, for a number of those extensions and modifications and granting additional forbearance periods. At some point, these loans are going to come due, and the question is, will borrowers be able to refinance or to pay them off or to otherwise enter into some sort of a workout that gets the debt repaid? And the final point, the final hot topic tied back into all of this, we're starting to see some of these equitable issues bleed into bankruptcy scenarios as well. Bankruptcy courts are courts of equity, and courts, the judges in those cases, have the ability to make equitable rulings and decisions in addition to purely legal rulings and decisions. In a bankruptcy case in Virginia, a couple of examples of what I'm talking about here. Pier 1 Imports filed bankruptcy in Virginia bankruptcy courts. There was a motion filed in that Pier 1 case to require Pier 1 to pay its rents because it had stopped paying rents to its landlord. And ultimately, the court, over the objection of the creditor landlord, allowed Pier 1 Imports to defer a number of rental payment obligations for a period of time in that case. That was an equitable ruling in light of the current situation, COVID issues, governmental orders that are in effect, things of that nature. A second example of that comes from a bankruptcy court in Illinois. A large restaurant group filed Chapter 11 in February. They stopped paying their rents in March, and when their lessor made a request of the court to require them to pay their rents current and to cure their arrears and otherwise do as they're required to do under Section 365 of the Bankruptcy Code if they want to assume the leases post petition. The bankruptcy court did not require them to immediately cure those rents and pay 100% of the rental obligations going forward. Instead, in that case, the bankruptcy court looked at the parties' agreement, found that there was a force majeure provision in that commercial lease, and that the force majeure provision was triggered by the Illinois stay-at-home orders issued by its governor. Those orders limited the business from having on-premises consumption, and the court found that approximately 25% of normal revenue was able to be generated with its off-premises sales that it could legally engage in. So the court effectively cut the rental payment obligations by down to 25%. To be commensurate with those findings, and required that debtor to only pay 25% of its rents for April, May, and June of this year. And then once those stay-at-home orders went away and increased, there were additional changes there. But the bottom line is that we're starting to see these real-world issues that are largely outside of folks' control bleed into the equitable rulings of bankruptcy courts. And we can certainly see a situation where similar issues could arise for creditors who lease personal property in addition to real property. Certainly for creditors who have finance leases for equipment, or in the context perhaps of a creditor who has cash collateral rights that they are seeking to enforce in a commercial bankruptcy case. It's just something to keep in mind. We haven't seen those rulings here in North Carolina yet, to my knowledge, but given the trend in other bankruptcy courts and given the strong equitable powers that exist under the bankruptcy code, it's something that could come home and start to affect folks here as well. And with that, we'll open it up to Q&A, and I will turn it back over to Norman. Thank you.
Thanks, Tyler. Go ahead, Jen.
Oh, I was just going to say thank you, Tyler. And we are at just past the 1 o'clock hour, but we did have one question that we wanted to address prior to conclusion. And the question is addressed to Paul. The question is, Paul, on the subchapter 5 cases you have been a part of, do you think financial institutions have been treated fairly? How would you rate the trustees that have been appointed to run these cases?
Well, thank you, Joel. As a seasoned special assets guy, you know how to hit the buttons. Treated fairly, have banks been treated fairly in these new bankruptcy cases? Well, I can answer that in the cases where I prevailed, they were treated fairly. In all seriousness, this is a new law, and I've had cases in front of 3 judges where it was their very first subchapter 5 case. So they're figuring out how to deal with this. I do think they've been treated fairly. I think the judges are doing a great job interpreting the law and trying to facilitate these cases. The trustees, I've not really been impressed by the effectiveness of the trustees. They, so far in the cases in which I've been involved, have been more or less of a rubber stamp on the debtor's actions to put a plan together. They've not played an active role in the cases. They've not challenged the debtor in certain cases in which I thought were appropriate to be challenged. That's going to play out over time, and I think we'll see more trustees playing in that role and handling cases differently. Thank you for the question, Joel. Appreciate that. And Norman, why don't you send us off?
Sorry about it. I was muted there. All right, it looks like we don't have any additional questions. So I just want to thank everyone for attending today. And I hope you found the information presented to be helpful. If anyone has any questions that we did not get to answer today, or if you have any questions that come to mind later on, please feel free to call or email one of us, and we'll be happy to answer or discuss it to the best of our abilities. Again, thanks for attending, and we look forward to working with each of you in some fashion as the special assets world gets busier over the coming months. I hope you all have a great day. Thanks.
To echo Norman's comments, thank you all for attending today, and thank you, Tyler, Paul, Thomas, and Norman for your presentations. For those in attendance following today's webinar, I will send you an email with a list of articles related to the issues that were discussed today and other helpful information. We also will make a recording of this webinar available. We so appreciate you taking your time to join us today. We hope that you found the information we provided useful and applicable to the issues you may be dealing with. Thank you again. This concludes today's webinar.